Okay, just yell okay.
Okay, so I'm going to start the broadcast and give it about 10 seconds.
Okay.
The broadcast is now starting. All attendees are in listen-only mode.
Hi, everyone. My name is Megan Scheffling, and I am the Policy Analyst for the New York Association on Independent Living, or NIAL. Thank you all for joining us today for today's presentation. As you know, NIAL is strongly opposed to physician-assisted suicide, but we know that this is more controversial than many of the positions we've taken, so we thought it would be a good idea to give our advocates additional training before we start advocating against the various proposals in the New York State Legislature this year. As such, I am so thrilled to present our two presenters who are both leaders in the fight for disability rights in opposing assisted suicide across the country. We have Diane Coleman today, who is the President and CEO for Not Dead Yet, and Marilyn Golden, who is the Senior Policy Analyst for the Disability Rights, Education, and Defense Fund. Today they will be speaking to all of us on talking points in opposing assisted suicide. They will highlight many of the abuses we've seen in other states where this is legal and share their experiences in speaking to policymakers, the media, and other advocates who have opposing viewpoints. Participatory mode today. However, you can ask a question at any time by typing your question into the question pane, and our presenters will leave time at the end of today's presentation to answer your questions. Additionally, everyone should have gotten reading materials from me, as well as today's PowerPoint presentation. If for any reason any of you did not receive those materials, they will be posted shortly to NIAL's website. We're also recording today's webinar, and that will be posted to NIAL's website as well in the near future. With that, I will turn it over to Diane Coleman and Marilyn Golden.
Thank you, Megan. I really appreciate the chance Marilyn and I both do to talk with the folks who are attending today about this critical issue that is in particular going to be a major focus of activity in New York State, which has been designated as the #1 target of the proponents of assisted suicide in their leading lobby group. A good place to start is where we want to begin. If a person is given by media a chance to just give one soundbite, we have one, and I want to thank Marilyn for this really excellent summary of our concerns. And it's a quote that we often borrow. If assisted suicide is legal, some people's lives will be ended without their consent through mistakes and abuse. No safeguards have ever been enacted or even proposed that can prevent this outcome, which can never be undone. I sometimes say mistakes, coercion, and abuse. And that is really a solid summary of what we're going to be talking about today. I'd like to offer a little background before getting into the actual talking points that are most effective for you to use. And this background is something that I'm not legislators or reporters, but I just wanted to share some of my experience as Not Dead Yet is now entering its 20th year in dealing with this battle. Some people question the legitimacy of disability groups meddling and trying to do what they think of as taking away what they see as the general public's right to choose assisted suicide in the face of terminal illness. When we look, though, at the reasons for assisted suicide that have been reported in Oregon by the doctors that give leave. Next slide. We see that mental condition representing the study loss of autonomy, the decreasing ability to participate in activities that made life enjoyable, a loss of dignity, loss of control of bodily functions, such as incontinence and vomiting, physical or emotional reasons. There's a restriction in Oregon state. Both of those are where it is legal. And what these reasons tell us is that the people who are dying by assisted suicide are in fact disabled, whether they think of it that way or not. And as that reality became clear over the years, I ended up making a diagram of that. Next slide, which is a big circle of people with disabilities and a small circle inside the big circle of people with terminal conditions. What disability has to do with it is that people with terminal conditions are a subset of people with disabilities, and concerns that we're very familiar with are what are the reasons that they're asking for assisted suicide. So what is the disability role? Our experience makes us experts in both the concerns that lead people to request assisted suicide, how to address those concerns, and the dangers of legalizing assisted suicide. We live on the front lines of the healthcare system in a society that devalues old, ill, and disabled people. And you could say that we're the proverbial canaries in the coal mine who can understand and explain the dangers to everyone of the public policy of assisted suicide. I would say, unlike the canaries, we're not expendable. But I want to just emphasize that the talking points that we're going to be going over are to explain the dangers that a public policy of assisted suicide poses to everyone. So the first talking point is one that we call a deadly mix. The deadly combination of assisted suicide and our broken, profit-driven U.S. healthcare system. There's a cartoon that we like to share. It's a picture of a guy behind a desk in an office environment and another guy with a briefcase. And the guy says, "We're able to hold down healthcare costs through assisted suicide." Now, despite the frequent claims that there are no problems in Oregon where assisted suicide is legal, claims that are made by Compassion and Choices and the other proponents of legalization of assisted suicide, to the journals. An example that illustrates the deadly mix issue is Barbara Wagner, a 64-year-old great-grandmother who had recurring lung cancer. And another example was Randy Stroop, who had prostate cancer. Their physicians prescribed chemotherapy. For Wagner, it could extend her life, and for Stroop, it was to help relieve pain. But the Oregon Health Plan, which is the Medicaid agency in Oregon, sent a letter to each person saying that the plan would not cover the beneficial chemotherapy treatment that their doctor prescribed, but it would cover, among other things, physician-assisted suicide. So that's an example of the deadly mix. Related to elder and disability abuse and coercion. Under the Oregon and Washington laws, nothing prevents a friend or relative, even an heir to the person's estate, being able to encourage forms as a witness, pick up the prescription, and even administer the drug, although technically it's supposed to be self-administered, quote unquote. Because there's no independent or objective witness required at the time of death, which could be weeks or months, or longer in some cases, years, after the prescription is obtained. If there's no independent witness, then we don't have any real evidence or way to know whether the drug was given and whether it was with or without consent at that time. Who would know without a witness? So factors that make this especially important that we've learned in more recent times is that 1 in 10 elders are abused in the U.S., according to the Administration on Community Living, the federal agency that now independent living is part of. And there was recently a study reported in the New England Journal of Medicine that also agreed with that figure. 1 in 10 elders are abused. So that's a very high rate of prevalence that shows some of the danger of legalizing assisted suicide in terms of family pressures, because the primary perpetrators of elder abuse are close family. What we Oregon courts is that half of the cases have not had a health provider witness present at the death. So in those cases, assuming that a health provider witness is independent, there wasn't an independent witness of the death, and we don't really know what happened in the end to that person. The third talking point is one about addressing pain. Certainly, pain is one of the key issues and selling points that proponents of assisted suicide emphasize. But there's been a lot of progress in palliative care in the last 15 to 20 years. And I'd like to share a story from my own family's experience. My father died of bone cancer in the late 90s. And for several months, he was in increasingly severe pain. And it got to the point that it was very difficult for him to even get out of his chair that he sat in the living room and get to his bed at night. He gave up on and requested hospice. His oncologist had been giving him various pain-relieving medications, 4 different ones, but it just really wasn't working. Then the hospice nurse came in when he finally gave up, quote unquote, and using the same medications, the hospice nurse changed the schedule and dosages for the use of those medications, and suddenly he felt so much better. He got up and went to see his neighbor next door, and they played putt-putt golf. He just felt so much better. And it really made me very angry that his oncologist had not understood that palliative care expertise was available and would help them. And there's still a need for more education of physicians about palliative care, but we're a lot further down the road now than at that time and what happened with my father. And I think we just need to be sure that people understand that they can seek that help. Even in a small number of cases, though, perhaps due to allergies to some of those medications, traditional palliative care may not be effective. In those rare instances, palliative, where the person is made unconscious through the use of various medications, other types of pain relievers, and their pain is then relieved because they're unconscious, and they continue in the dying process without having to deal with the pain. So that's similar to something that people are familiar with, I think, from TV dramas, where doctors induce a coma for a burn victim. That's basically what they're doing, is inducing a coma. So these are legal alternatives that are already available to address terminal pain. Now I'd like to ask Marilyn to talk with you all about safeguards that are supposedly in the bills and how they have failed. Marilyn, could you take it from here for a bit?
Thank you, Diane, so much. Is my sound okay?
Yes.
Okay.
Very clear.
Greetings all. We are assured by proponents of assisted suicide over and over again that their bills and proposals have very thorough, extensive safeguards so nobody is endangered. This is not true. The safeguards are actually hollow, and I want to talk about a few of the main ways that is the case. One big one, one that applies particularly to the disability community, but it really applies to everyone, we call the fundamental loophole of terminal illness prognosis. The Oregon law and all the bills that imitate it that we see in states across the country, we call this kind of proposal the Oregon model. The Oregon model proposed that it's a clear disability who are terminally ill with 6 months to live, and everyone else. Everyone else is supposedly protected and not eligible for doctor-prescribed suicide, but it is extremely common for medical prognoses of a short life expectancy to be wrong. Studies overwhelmingly indicate how many errors are made, often predicting death when people may live for decades. So the effects of legalizing assisted suicide are very broad, including many people who may be mistakenly diagnosed as terminal, but have many meaningful years of life ahead, including some of the points on the slide, such as that some of the bills include people with conditions that cause death even, if they are not treated, such as diabetes. And also we see other terminology in the bills, such as incurable or irreversible, words that really could describe many people with disabilities, insensitive they may be, those words, but the big thing is that they're not at all, somebody, could easily have the condition someone society regards as incurable, or it may be irreversible, but in no way is terminal or threatening their life anytime soon. To be very afraid if they are not well informed, particularly people with new disabilities, treatment, and lose good years of their lives. Shows another cartoon that we have on this. The doctor at a hospital patient's bedside, and the doctor is going, "Of course you don't feel any better. 2 years ago, I gave you 6 months to live. You do the math." That says it all. We have some examples, real-life examples. One is Jeanette Hall of Oregon, who was diagnosed with cancer in the year 2000 and was told she had 6 months to a year to live. She knew about the assisted suicide law and asked her doctor about it because she didn't want to suffer. But her doctor encouraged her not to give up, and she decided to fight the disease. She underwent chemotherapy and radiation, and 11 years ago, she wrote in a letter to another state, to Massachusetts, where assisted suicide was on the ballot. And she wrote a major paper in Massachusetts, and she wrote, "I am so happy to be alive. If my doctor had believed in assisted suicide, I would be dead. Assisted suicide should not be legal." Another example is John Norton, who was diagnosed with ALS, Lou Gehrig's disease, at age 18 and given 3 to 5 years to live. 6 years later, the progression of his disease suddenly stopped. He is alive at age 77 with a wife, family, and retired from a successful career. He stated that if assisted suicide had been legal at the time, he would have used it, but also has been very happy to be alive all along the way and continues to be so. Before going to the next slide, I actually want to call on J.J. Hansen, who I believe is registered. And J.J. is head of the Patients' Rights Action Fund. And his personal life is another example. Terminal prognoses are notoriously inaccurate, and the significance of that. Could the facilitators help get JJ on to speak? Can you be louder?
Can you hear me a little bit better now? Is that good audio?
Louder would be better, I think, if possible.
All right, I will try to speak as loud as I can. If you can't hear me, I will just call in through the phone and we can just skip a slide, because right now I'm going through the computer. Is that a little bit better?
That is better. Any other feedback on the sound?
Okay. I will. Good, excellent. Sorry.
Yeah, go ahead, JJ. Thank you for joining us.
Oh, not a problem. Thank you for having me. I think this is just a wonderful opportunity for people to gain more knowledge about the key issues related to right off of the key area that we're talking about at the present moment. The doctors are not always right. And there is a high level within our society, within our medical system, of doctor error. You gave a good example of Jeanette Hall. Jeanette Hall, as you mentioned, in 2000, she was given a similar terminal diagnosis and 6 months left to live. She went to her doctor, asked for the suicide pills, which were legal in the state of Oregon at the time. She actually went back several advised her to think about it. She should go that route because he had treatment options for her. And on several occasions, she came back with the same thought. Finally, he through counseling, she said, no, fine, I'll fight through this, and I'll go through treatment. I actually had lunch with her. That's how I know this. I had lunch with her 2 months ago out in Oregon, and she's doing wonderful. And you just talk about someone who's enjoying her day-to-day activities. She's having a wonderful time. She enjoys being alive. She's very thankful that she did not go down that route. So it's just a great example that the doctors are not always correct. Her initial prognosis was not accurate. In my case, I was diagnosed in May of 2014 as a terminal brain cancer patient. And I use the word terminal normally in my own example specifically because that's what I was told. I was told that I had 4 months left to live. The doctor who gave me that prognosis was someone who said, you really not much you can do. Go home and enjoy the time you have left. On second and thirds. Ultimately, I was able to have brain surgery, and even at that point in time, I met with the first neuro-oncologist I was assigned, and he said there's no surviving from the type of brain cancer you have, which is known as grade 4 glioblastoma multiforme. That is the one of the rarest and deadliest types of brain cancer that exists. And so what do you mean? We researched it, and we found other people who've survived 10, 12, 13 years. He goes, those are all probably misdiagnosed. And that's what he told us. We brought him some research, and he goes, that's very scientific. I don't agree with that. Well, ultimately, long story short, we fired him as a doctor. But it just shows you that they are not always correct. And one of the key thing that I reference when talking about doctor are in just the way that we as humans respond to doctors as people who we trust and we have that relationship with. There's a book called Love, Medicine, and Miracles written by Dr. Bernie Siegel. He was a Yale professor. And in that book, he breaks down terminal patients into 3 categories. One is what he calls those who are going to fight, and that's top 20%. On that bottom 20%, they immediately, at the end of life, they might be depressed. There might be another type of situation. They just say, I don't want to fight. I'm going to accept this for what it is, and they go. The remaining 60%, the majority of the population, don't know what to do. They don't know where to go. They don't know who to trust or who to be guided by. And so they're looking for someone to advise them on where to go. Well, the problem with the legalization of assisted suicide, the problem with creating that as a social norm, is that 60%, instead of having the potential, and this may not happen, but having the potential to be brought up in that top 20%, where they're going to be giving options to fight and try and survive, looking for different types of treatment, looking to try and extend their life, which they may value. They will be pulled into that bottom 20% because many of the problems with the law, which you'll hear more about during today's talk, that brings them down. And it pulls them into that bottom 20%, ultimately leading to perhaps an early end of their life, which otherwise could have been extended, again, relating to that misdiagnosis that they might have received. 7th key point, and then I'll turn it back over to Marilyn, is that you have this issue which was referenced earlier, which is the economic issue here of insurance. You had a couple major things happen here in the last 10 years, the last decade. Primarily the most significant one would be the Affordable Health Care Act, or Obamacare. All right, what did that do outside of creating just the way that our healthcare system is provided in the United States? It created the economics, an economical change for the insurance companies. And organization formerly known as the Hemlock Society, which now is Compassion Choices, our key opponent on this issue, their original founder, Derek Humphrey was his name, wrote a book in 2000, and he said in that book, and I will quote, "Economics, not the quest for broadened individual liberties or increased autonomy, will drive assisted suicide to the plateau of acceptable practice." Economics. What does that mean? Right now you have an impact where if you are a private insurance company and you are looking to raise profit, and that is what you do for your shareholders, if you have a patient, say, use myself as a perfect example of this. I was considered terminal. I am still considered somewhat of a terminal patient, even though my brain cancer is in remission after almost 2 years. I'm still in that category. So now, if you're looking at me from purely financial means, I could have received, upon my original diagnosis and prognosis, 4 months to live, I could have been eligible under the law to receive the assisted suicide pills, which would have cost probably around $300, one-time cost. I would have gone home, taken that 4 months, seen how long I would have lasted, and I would have used those pills to end my life. Or fighting, as I did. If you look at the first 6 months of my fight, initial hospitalization and biopsy, $20,000. fix alone, now you're looking anywhere between $200,000 to $250,000 of what my expense is back to the insurance company versus $300 that would then go back to them. Where do you think the financial incentive goes? And this is a good point to make to people for them to understand that there is a interest for insurance companies to want you to choose, and probably shouldn't use a specific term of choose, but want to lead you towards assisted suicide and taking that route. So with that, hitting those two key points there just to touch on those areas that we've heard about, I will turn it back over to you, Marilyn. Thank you.
Thank you, JJ, very much. The next safeguard issue we want to look at is doctor shopping. Doctor shopping is when, if you ask for lethal drugs and your doctor says no, you don't qualify, you or your family looks for another doctor who will say yes. This is what happened to a woman in Oregon, Kate Cheney. Although a psychiatrist had concluded that she had increasing dementia, and also a medical professional had written that she was being pressured by her adult daughter, she died after taking another doctor's suicide prescription. It's become common knowledge in Oregon that if your doctor says no, call the main organization that supports assisted suicide. As JJ said, it's called Compassion and Choices, used to be known as the Hemlock Society. They will refer you to assisted suicide-friendly doctors. They have been involved in a surprising 75 to 90 reported assisted suicides in Oregon. Shopping for another doctor who will say yes will get around the law's weak safeguards. Documentation of the high percentages of cases facilitated by Compassion and Choices in 2002 and 2003 and 2008, with a note that these are typical. They're not outliers, but are typical of what we find in various data on Oregon. I want a couple further points on this. The next slide shows how short the median length of relationship between physician and patient in Oregon has been over most of the years of the operation of assisted suicide. A mere 13 weeks, which underscores, this is not your family doctor who's been with you for years. Often described kind of protection in the system by proponents. Moving on to the next safeguard, one I'll say so-called safeguard, one that is particularly key for the disability community is the extent to which people with depression and other psychiatric disabilities are at significant risk. A very important and dramatic case in Oregon was a 5-year history of severe depression, suicide attempts, and paranoia. His prescribing doctor said a psychological consult was not, quote, necessary. Yet when finally provided high-quality medical and social services, his desire for assisted suicide vanished. He was able to reconcile with his estranged daughter and live 2 years post-diagnosis until he died a natural death. If Oregon's safeguards are so strong, how did someone like Michael Freeland obtain lethal drugs? Oregon's own statistics show that in recent years, only 3% of patients are being referred for psychological evaluations, and over all the years, It's also important to know that doctors are often unable to diagnose depression. And on the rare occasions that psychiatric assessments happen, they are usually pro forma, because a doctor who thinks her patient should receive lethal drugs can herself shop for a psychologist or psychiatrist who will make a finding consistent with that view. Also, here it is, the consulting doctor is often unable to diagnose depression, particularly when limited to the one session. The law is allowed, the assessment is allowed to be as little as one session. Only gives an opinion about whether the person's and their factors resulting in impaired judgment. They don't treat them in any way. They don't treat any depression that may be diagnosed. And another point related to this is illustrated by this drawing of a person with a disability using a motorized wheelchair. And she sees to her left a suicide prevention program, but she can't get in because there are steps up to the door. But around the side of the building, featuring an international symbol of access, there is a ramp entrance. However, there's a big sign on the top of that entrance saying assisted suicide, meaning basically that assisted suicide creates a double standard. If you're non-disabled and want to kill yourself, you get suicide prevention services. If you have a disability and want to die, if you have a health situation that compromises you, you will get assisted suicide, resulting in this two-tiered system that results in death to the socially devalued group. And another very important point about the hollow safeguards in the Oregon model is the issue. The Oregon model protects patients when there are pressures, often from family, whether financial or emotional, that distort patient choice. So there is a significant danger that many people would choose assisted suicide due to an external pressure, including elderly individuals who don't want to be a financial or caretaking burden on their families, who might make a choice that is to die sooner to save their family's money. And it can be a situation, we know that not all families are happy, but it can even be a situation where the family is happy, but the ill person does not want to be a financial burden. And there's no provision in law, no amendment that can and mainly having happened. The first person to use had financial problems, had been unable to work due to a disability, and was forced to declare bankruptcy. Yet, the New York Times quoted the director of Compassion and Choices of Washington State, who said that her situation presented, quote, none of the red flags that might have given his group pause in supporting her request for death. Yet proponents tell us that financial pressures have never played a role. Another example is Thomas Middleton, who was diagnosed with Lou Gehrig's disease and moved into the home of someone named Tammy Sawyer in July of 2008 and died by assisted suicide later that month. 2 days after he died, Sawyer listed his property for sale and deposited $90,000 into her bank account. a federal investigation into real estate fraud indicted Tammy Sawyer for first-degree criminal mistreatment and first-degree aggravated theft. But the Oregon State agency responsible for the assisted suicide law took no action at all, really illustrating that there is no investigation of abuse. Actually, something that we're now going to change hats and move on as I turn back to Diane for other points in addition to the safeguard issues.
Thanks so much, Marilyn. And I just want to point out that the stories of individual cases from Oregon and Washington are included in one of the readings that you received that Marilyn did a wonderful job compiling the document called Oregon and Washington State Abuses and Complications. Not only does that document include the stories that you've just heard, but also citations to the independent mainstream media or other sources that document those instances. So when we see legislators or others who've been told that everything's fine in Oregon and Washington, it's not true, and that document is the best evidence of that, and I really thank Marilyn for putting that together for all of us to use. But there is one thing about the safeguards in the Oregon and Washington statutes, and that's that the safeguards do work for someone, namely the doctors. Doctors are actually not able to be held liable civilly or criminally in any way under these statutes if they claim to have acted in good faith, which is an impossible standard legally to disprove. The good faith standard basically makes all the other so-called safeguards unenforceable. For all other procedures, in contrast, doctors would be liable if they're negligent. So it's a huge gaping hole in the scheme that's been designed. It's really basically not a statute conferring new rights on patients, but rather it's an immunity statute for doctors. That is the point of it. The operative language in the statute is for immunity. And what we see in Oregon is that there's really minimal data and fatally flawed oversight. The doesn't, have any idea how there may be. Bill requires the doctors to file any forms with a state agency to even do the minimal kinds of data that we see in Oregon. The state has not also been able to monitor noncompliance. They've admitted that, particularly in the earlier reports. They say they're not able to detect non-reporting or noncompliance. They don't investigate abuse. They've actually issued a press release out of the state of Oregon saying we have no authority or resources to investigate. The underlying data that the doctor, form the doctor files, and there's another form that comes in from the pharmacy to the state, is destroyed annually. So all you have left is the statistical report. And there's a possibility that documents have been falsified. Now, sometimes people say, when we talk to them, legislators or reporters or others, that we're just worried about the slippery slope, that we're caught up in a fallacy thinking that that the statute is going to go beyond the designated group. That's not correct. Basically, assisted suicide proponents are in fact engaged in what you would call an incremental strategy. It's not a slippery slope. Politics in particular, they really need to get enough states to hit critical mass, because this type of law is a state-by-state issue. The U.S. Supreme Court already said it's not a constitutional right. And so the state individually address it, if they're going to address it at all. But outside the United States, where a law passes and it affects the whole country, it is possible to see what the incremental strategy leads to. And there's a psychiatrist who studied in particular the Netherlands who wrote, the Netherlands has moved from assisted suicide to euthanasia, from euthanasia for the terminally ill to euthanasia for the chronically ill, from euthanasia for physical illness to euthanasia for psychological distress, and from voluntary euthanasia to non-voluntary and involuntary euthanasia. Once the Dutch accepted assisted suicide, it was not possible legally or morally to those who could not affect their own death. Nor could they deny assisted suicide or euthanasia to the chronically ill, who have longer to suffer than the terminally ill, or to those disease. To do so was justified by the need to make decisions for patients not confident to choose for themselves. And this is Dr. Herbert Hendon from Congressional Testimony. Dr. Hendon is now the head of the Suicide Prevention Initiatives in New York City. He's former medical director of the American Suicide Prevention Foundation. And he is, I'm happy to say, and his organization, part of the New York Alliance for opposing the assisted suicide bills. And if you do want to look up their longer statement online, they've listed it in the New York Alliance website, which is noassistedsuicideny.org. Some other pointers we wanted to share is, if you have a personal experience, like the one that J.J. Hansen shared with us of being diagnosed to have a terminal condition that isn't as terminal as it was as he was told it was, and other kinds of personal stories that you may have. Think of a way to tell. You can also use the Maryland provided examples of these points. If you're asked about religion or abortion or politics, which does sometimes get brought up by legislators or others who have kind of bought into the compassion and choices notion that this is all about compassionate progressives versus the religious right. What you can say is, my reason for being here is my concern about whatever your talking point is. And if they ask it in, again, just give the same response. Assisted suicide proponents often say that their only or main opponents are Catholics and pro-life groups, but this is not true. And similar coalitions and increasingly over the few years, I've seen a real change in what news articles print, and many times they very clearly acknowledge the role of the disability advocacy community in opposing these bills. We can also say that we're here due to our public policy concerns, on behalf of people who are at risk, which includes people with disabilities, elders, poor people, people from diverse backgrounds, and many others who would be endangered by assisted suicide laws. About dying people who are suffering, then it's really appropriate to say that our hearts go out to anyone dealing with a terminal illness and their families. The assisted suicide laws are so dangerous. They harm far more people than they could help, and these harms can't be ignored. And I'm glad to be able to report, too, that working against these bills, we have been successful, along with our colleagues, in defeating them. But it really is important to do our homework. And I'm grateful to all of you today for joining us on this webinar, because this is the kind of homework that's needed to really be prepared to deal with this controversial issue. In 2014, disability advocates were instrumental in defeating bills in Massachusetts. Things really escalated, and there were bills in multiple states where we were again able to play a significant role in defeating them. In Colorado, Montana, Wyoming, Utah, Maryland, Connecticut, Nevada, Alaska, New Hampshire, Iowa, Maine, and Rhode Island. And we're expecting that type of level of multi-state activity again this year. But like I said, New York is the #1 target this year. So in closing, I would say what the proponents of assisted suicide do is they focus on their slogan, really, of choice. But in the world we live in, choice is, I would say, an empty slogan. And our response to that is social justice. We are calling on people to recognize the inherent discrimination and dangers of assisted suicide as public policy. That's social justice. So at this point, we'd like to open to questions. And I think some of them may have been shared already, but maybe if the question process could be facilitated, I'm going to see if I can figure out how to work the system. I want to rely on those of you who are more familiar with it.
Yes, maybe we should start with sort of oral questions. We also have some written submitted questions, which we hope we can get to all of.
And this is Sandra with Nile. So for oral questions, if someone wants to electronically raise their hand, there's a little hand icon, and if you click that, I'll see that on my end, and I can unmute you so you can ask your question verbally.
One question, I see one, is a New York bill has not been passed yet and is in the process of being written. Therefore, to use that as data seems unfair, don't you think? Now, there are actually bills pending. There's 2 bills, and each of them has a companion bill, one in the Senate, one in the Assembly. And the language has already been written. So we're the only significant difference, excuse me, between the New York language, namely that there's no state reporting. Otherwise, the terms are pretty much the same, and the analysis is pretty much the same. We're basically using the Oregon data to explain how implementation has gone in those other states to illustrate the problems. Marilyn, do you have anything to add to that?
No, but thank you. I think it's been beautiful. Exactly. I just my sense is that we haven't heard much from people yet, and I'm just curious if other, you know, if time maybe somebody else has a. If not, we can go to some of the submitted questions. Should we go ahead and do that?
Yes, the only questions we're seeing are the submitted ones. We're not seeing
Okay.
anyone with their hands raised right now.
Well, somebody asked what were the other things and how affordable were they, and I think that must have been asked when we were talking about assisted suicide as a deadly mix with a broken, profit-driven healthcare system, and how they they received letters from the Oregon Health Plan that their prescribed chemotherapy was denied, but the letters offered to pay for, among other things, their assisted suicide. I'm not sure what the other things were, and I don't know if their affordability is as idea that but would have been yes that that's what I was saying. Barbara Wagner and Randy Stroop are where that phrase comes up. Diane, did you have another comment on the other?
No, I don't think I have any comment to add to that.
Okay. Someone else said, is palliative care different from ordinary pain treatment? They asked because last year they and hallucinate. Oh, I'm sorry. Palliative care, but goes treatment for pain. Palliative sedation is different still. As palliative care, because some people do react badly to. Diane, anything else on that one?
No, I think I've been having trouble scrolling through the questions. There's quite a few now. And,
okay.
But I don't have anything to add to that. I don't have any more detail about Barbara Wagner and Randy Stroop's other things than those that they received. I know Barbara Wagner's case was reported in ABC News, and I don't remember the source for Randy Stroop's. So that detail is probably available, but I don't have it.
Yes, I don't either. And I think the questioner also added, absolutely their treatment should have been funded and is ridiculous that it was not just wondering what their other options were. And no problem, it's a perfectly good question, and agree with you that it should have been funded. Let's see. So another person asked, do you feel that even though a patient has to be seen by 2 doctors to determine whether or not they are even eligible for death with dignity, which is one of the names, the terms that the bill supporters, these bill supporters use to call it that, even though the person has to be seen by 2 doctors and see a therapist if they show any signs of depression, anxiety, and mental illness, and cannot be given the go-ahead until the therapist clears them, stating they are of sound mind, that they are still pushed, I guess, do we feel that they are still pushed into making this decision? If so, what can be done without taking the bill away from those who truly want to use this? I have to disagree just a little bit. That they have any signs of depression, anxiety, and mental illness. The doctor wants to, but we've talked about how few that happens with. Something like, in recent years, only some 3% of cases. It's not true that I'm stating they're of sound mind. I mean, I think it's true that for them to get lethal drugs, the psychiatrist, psychologist, you know, to avoid them getting the lethal drugs, the psychiatrist that that they do not have the mental capacity. But that is a very in-depth and problematic issue, because what the Oregon model usually conveys is not, you know, is the person depressed, but do they have the mental capacity to make decisions for themselves, such as can they make financial decisions? People can often make, for example, financial decisions for themselves and still be depressed. So it's 2 different standards. So it's very worrisome, because the Oregon model emphasizes capacity rather than depression, or what some may call a mental illness. I would not necessarily say I think that every user of the Oregon law or the Washington state law are being pushed into making the decision, but it appears that some are, or certainly easily could be, because of the things Diane was saying earlier about how an heir, someone who stands to inherit from the ill person, is legally allowed to be a witness under the Oregon model. The second required witness can be their best friend. No objective witness is required at the death, so who would know what happens? We actually don't think anything can be done to protect people who are would-be victims of these problems without, in a sense, what the questioner said, taking the bill away. We understand that there are people, you know, who say they want to use it. But our concern is what Diane said at the end, which is that it has so many dangers to other people. And a set of harms that is made legal. Did you have any other comments on?
I would want a logical issue. Does a very minimal standard of capacity, saying that the person, the issue is whether the person has impaired judgment. And if the doctor thinks that, well, you're depressed and you have anxiety, but your judgment is not impaired because you can understand that you have this diagnosis and you understand the fact that if you take these drugs, you'll die from them, that's capacity in this situation. So that's one concern. I'd also like to say that a lot of the discussion of the assisted suicide issue doesn't really make a distinction that is a very real distinction between suicide and assisted suicide. And there's an implication in the general discussions that people who are ill or disabled in these ways cannot commit suicide independently, and they need to have a doctor give them the means to do so. But that isn't correct. We're not depriving people of the ability to commit suicide that they already have, and suicide is not illegal. But assisted suicide is a very different matter because it brings in the issue of potential coercion and abuse, and because it sets up a public policy and a socially approved approach to doing this that is in and of itself harmful. So I just want to make that clear.
Thanks, Diane. That's really a good point. Set of points.
We're talking about outright opposing these bills because they are about assisted suicide. So I know there are a lot more questions.
There's a few more, yeah. And I think if the hand raising should use that. Objected to the 9, and I look back on what slide 29 is, and I didn't see data anywhere around that part of the slideshow, but I think the data being referred to was probably the data about how many of the reported suicide uses of the reported uses of the assisted suicide bill in Oregon were facilitated by the proponent group Compassionate Choices. That data, there's two sources for that data. One is Compassionate Choices itself, before they stopped providing the data because, I believe, because it made them look bad. The second source is Dr. Ken Stevens, who I need to look up his articles, but that data is available. I have to go back and remind myself where it came from. So there are two sources of data for that bill. Let's see. Someone said there is a difference between assisted suicide and death with dignity that I wish would be pointed out, and I'm not sure what difference that is other than the terminology.
In fact, I think there is a language issue. The bills that are out there so far, the proponents of assisted suicide label them, the first round were death with dignity. Then they began to use the terminology, which they're primarily still using, aid in dying. And what's concerning about that terminology is that it threatens to confuse people between the measures that doctors can provide to assist somebody who is dying in terms of relieving pain, the basics of palliative care that we were discussing earlier. And on the other hand, the idea of doctors providing active measures to cause death. And that distinction between, you know, assisting people with palliative care but letting the process of natural death take place is not the same as the idea of active measures. The law makes that distinction, and so does the medical profession. And, you know, we should mention the New York Medical Society, the AMA, and so forth, oppose legalization of assisted suicide as inconsistent with their Hippocratic oath and, you know, their basic ethical approaches to medicine.
Another dimension of this name issue that you were talking about, Diane, is that some people in the disability community have been very offended by the term death with dignity because it suggests that unless your death is by assisted suicide, you're not dignified, or that, you know, the rest of us do not have dignity. Terminology is a very contentious and complicated issue when it comes to assisted suicide, and we could talk about it for a long time. I don't know if we should. We use the term assisted suicide because it is accepted in the legal and medical literature, and also because it is a description of what actually happens. Aid in dying could be, as one of my teachers on this issue terms it, could be plumping the pillow and mopping the brow. It can be anything done to assist a dying person. So we just use it, assisted suicide, because it's a little more descriptive. Let's see.
And this is Sandra Niall. We also have a hand up. I'm not sure if we want to go to that. So the hand up is Sharon Shapiro. So Sharon, I'm going to go ahead and try to unmute you so you can ask your question.
Okay. Hi everyone. Hi Diane. I just want to point out the doctor is making the ultimate decision, not the patient. It's a falsehood if we think that the patients are executing their own decision-making capacities. The fact that doctors decide who has a justified cause to die puts the doctor in control, not the patient. And we need to remember that.
That's a very good point, and very well stated. Anyone could ask for assisted suicide, but it is the doctor who decides whether the person is eligible. The doctor diagnoses whether or not they have a terminal condition, decides if they have capacity, is charged to figure out if they're being coerced. Although, frankly, you know, any coercion that's coming from sources outside the doctor's office, how are they going to know? I mean, much family abuse occurs behind closed doors, and doctors aren't all that good at identifying when that's happening. So, yes, the doctor is basically given the control under these bills. to decide who gets suicide assistance and who gets suicide prevention.
Very true. There's a couple more. One is, you mentioned that someone who was diagnosed with mental illness was not provided mental health support and instead was deemed qualified for assisted suicide. Was that person diagnosed with a terminal illness? Yes, he was. That was Michael Freeland. He did have a cancer diagnosis. He had a terminal diagnosis. And it's true, some people have said, well, shouldn't he have access to this if he's been diagnosed as terminally ill? The concern here, adult life, significant disabilities, which raise a lot of questions about protections for people in that situation. His case was documented and how few protections there are for people with, the another doctor that I more baldly that an overdose of barbiturates is not standard of care for someone with depression. I don't mean to take Michael Freeland's terminal diagnosis lightly, but I do mean to say that it opens up a very serious social issue that is of concern to the disability community if an avenue where it just is sort of a way to obtain lethal drugs for people in that disability category. In Massachusetts, where, as Diane was saying, I think this was on the ballot, a leading advocate for people with psychiatric disabilities named Ruthie Poole wrote that as people, many of whom, and she's somebody with a disability, very much part of the disability community, as people, many of whom have suffered from major depression in the past, we can relate to the desire for an easy way out. Depression is treatable and reversible. Suicide is not. So that's the issue, whether or not the person has a lethal diagnosis, particularly given the legal alternatives that Diane described earlier in the webinar available to people with terminal diagnoses. The last question here is, I think the person is making the point of the difference between what they see as death with dignity and assisted suicide. They're saying death with dignity is used to help people, whereas anything that includes the term suicide is meant as something that is secretive, shocking, impulsive, and/or violent. My response to that would be some people attach those things to the word suicide, but many others have said that suicide simply means taking your life. You're an individual who, through their own actions, ends their life. That's what the literal meaning of suicide. You have to have a lot of other connotations, just trying to term here. Any other points on that, Diane?
Yeah, I would just add that and assisted suicide terms that have been used in the medical literature. They're the names of policy statements from the and those are the terms that were being used by all parties for many years, and it's only really since the last maybe decade or than that, where entities, relations, and focus groups to develop alternative language. But the physician-assisted suicide language is really what was used by everybody before and is part of the policy literature on this. I wonder, are there any other, questions or points that people would like to raise, either in the question box in writing or by raising your hand?
This is Sandra. We don't have any hands up right now. And it looks like most of the questions, I think, have been addressed.
There's a last one that is a tactical.
Suggesting that we Richard Godfrey, who's the chair of the Assembly Health Committee, he is a from Disabled in Action. Not him repeatedly over the decision, and they really have not been successful in convincing him. But I think hopefully the support of Niall on this will help make a big difference as well.
All right, well, it seems like you guys have answered all the questions. Marilyn, Diane, thank you so much for your time today and sharing your expertise with us. Thanks also to J.J. Hansen, who came on the call and shared his personal story. I think it was very enlightening for all of us. Once again, we recorded this webinar, and all of the materials which were sent out, as well as a recording of today's presentation, will be archived on Niall's website for anyone who wants to review or to share with other colleagues at your center.
Yes, thanks so much. Thanks to Niall.